All right. Oh, I'm sorry. Give me 1 second. Okay. All right. This is case number 19454-5001. The people of the state of Michigan versus Angelo Mobley. The defendant is charged with 1 count of operating with a high BAC. Today is the date set for pre-trial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Janice Stevenson appearing on behalf of Mr. Angelo Mobley. Mr. Mobley, good morning again, sir. Please say your full name.
Ms. Stevenson, I promise you, you might have to do something different. I don't know why.
Okay.
I could barely hear you, so I don't know.
Okay. All right.
But Mr. Mobley, state your name for the court.
Good morning. My name is Angelo Mobley.
All right. Mr. Daoud, I assume you want to go back in with your client.
We have a plea offer. I just want to prep him with the interpreter, please.
All right. With respect to Mr. Mobley, today is the day. Is today the day set for a first-time pretrial conference? This is a 2019 case.
Yes, Your Honor.
All right. Ms.
Thank you, Your
Stevenson,
Honor.
how are we proceeding?
Mr. Mobley will continue his plea of not guilty, Your Honor. We're asking that this matter be set for final pre-trial
Mr.
conference.
Mobley, can you hear your lawyer?
Kind of.
Ms.
Okay,
Stevenson.
I'll come into the courtroom.
Okay.
Thank you, Your Honor. Mr. Mobley will continue his plea of not guilty. We would ask that this matter be set for final pretrial conference. We would like to be heard as to bond, Your Honor.
The court will continue a not guilty plea on behalf of Mr. Mobley. I will set the matter for a final pretrial conference. Mr. Flanagan, how many do I have on April 23rd, please?
4.
Court sets the matter for final pretrial conference, April the 23rd at 9:00 a.m. Discovery should be submitted to defense by March the 22nd. Ms. Stevenson, I'm sorry, as to bond.
Thank you very much, Your Honor. Mr. Mobley at arraignment was ordered to have an alcohol tether. To my knowledge, there have been no violations of that tether. I would ask that the tether be removed at this time. We'd have no objection to random urinalysis.
Any response from the people?
Your Honor, if the court is inclined to remove the alcohol tether, we are asking for random urinalysis testing at least twice a month.
Court is going to remove the alcohol tether. Mr. Mobley must submit to urinalysis twice a month. Since he is present, he can go across the hall with the order from the court so that that urinalysis can be set up through probation. Anything further?
Not from the people, Judge. Thank you.
Mr. Mobley, have a seat in the courtroom and wait for the copy of the order removing the alcohol tether.
Okay, thank you.
Thank you, Your Honor.
You're welcome. Mr. Brown, I'm going to do I'm going to do Mr. Land's pretrial first, and then I'm ready for you.
Thank you, Judge.
You're welcome. Sir, if you could please come completely into camera and make sure you're sitting straight. Thank you so much. All right, this is case number 225878602. The People versus Cartier, I think.
Yes, Cartier.
Hold on. Shaquan Casey. The defendant is charged with, I believe, violation of the marijuana statute. And today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Ivan Land, P65879, appeared on behalf of Cartier Casey, who's present on the screen, Your Honor. We have no objection to holding these proceedings by Zoom. Thank you.
All right, and Mr. Casey, please state your full name for the court.
Cartier Shaquan Casey.
Thank you so much. Today is the date set for final pretrial conference. Mr. Land, how are we proceeding?
Your Honor, my client is going to plead guilty, but he wants to plead. It's either could be HIDA, Your Honor, or 7771.1. We are asking the court for cops to either one of those, Your Honor. And it's a very we're asking, and I'm asking for a lot, Your Honor. Don't get upset. We're asking for a very short time of probation. This was a matter that stemmed from a bunch of felonies that were all dismissed, and the misdemeanor had to come to this court. I told my client that because of the weight of the marijuana, it would possibly be not good at trial. So we're requesting cops to probation, small time. It was twice the legal limit, Your Honor, either under 77.1 or HIDA, Your Honor. Thank you.
So let me just bifurcate what you just said. Your client wants to plead guilty, but he wants me to give a Cobb's evaluation?
Yeah, I don't know if it was going to be that this court wanted to, in the prosecutor, I guess she would have to chime in as well to 771.1 or HIDA. He's HIDA eligible as well, Your
Honor. How old is he?
Mr. Casey.
24.
So HIDA would have to be between you and Ms. Ritter. Do you want to go into a breakout room with Ms. Ritter?
Yeah, that's fine. I think she had said it like 10 months ago. She was okay with it, but we can go into it.
Well, why are we here and it's 10 months later?
Because I kept kicking the can down the road, Your Honor.
Okay, because I was getting ready to say, I know I didn't kick the can 10 months. I know. All right.
Yeah.
So, Ms. Ritter, the people are okay with HIDA?
Judge, can I just have a breakout room with the court, Mr. Land, regarding this?
Oh, you said the court and Mr. Land?
Yes, please. Real brief, Judge.
All right. Mr. Land, I'm going to send you to breakout room number 1.
Okay, thank you.
Okay. Oh, there's Mr. Casey. All right, so we're back on the record. And let me allow, okay. Mr. Land, we've had an opportunity to talk offline in the breakout room. Did you want to talk to your client before you proceed, or?
No, Your Honor, I talked to him this morning at 8 o'clock and told him what our position was.
Okay, so, Mr. Casey, your lawyer says that you want to, give up your right to a trial and enter a plea today. Is that what you want to do, Mr. Casey?
Yes.
Mr. Casey, I'm going to share my screen, and when I do so, on it will appear a constitutional rights form. Where is it? My question to you is, have you had an opportunity to review for yourself or? Nope. Okay, where's my constitutional rights form? Oh, there it is. Have you had an opportunity to review for yourself, sir, or to go over with your lawyer your constitutional rights?
Yes.
When you did that, Mr. Casey, did you understand your constitutional rights?
Yes.
Sir, do you understand that this is a misdemeanor and therefore you do have a right to a trial? However, if I accept a plea from you today, you are giving up your right to a trial. Mr. Casey? Oh, you're
Yes, ma'am.
okay. Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea?
No, ma'am.
Mr. Casey, are you currently on probation or parole? Drawing your attention to number 8.
No.
Finally, sir, drawing your attention to number 11, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes.
With that understanding, Mr. Casey, do you still want to give up your right to a trial and enter into this voluntary plea?
Yes, ma'am.
All right, raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Thank you. You may put your hand down. Who's going to voir dire Mr. Casey with respect to the factual basis?
I can, Your Honor.
You, all right.
Mr. Casey, on the date in question, were you in the city of Detroit?
Yes.
And you were in the city of Detroit. Were you in inside of a home?
Yes.
And at that home, did the police come inside of that home?
Yes.
And there was some marijuana found in the home?
Yes.
And the quantity of marijuana, do you believe it was above the legal limit?
Yes.
And you didn't have a license for that marijuana?
No.
I'm satisfied, John.
I'm not satisfied, but are the people satisfied?
Can I ask one more question, Your Honor?
You can, but I can tell you why I'm not satisfied. I just wanted to see if the people were satisfied.
You were in possession of that marijuana, correct?
Yeah.
Well, the house where the marijuana was that, did he live there? Was it his house?
He was not, it was a relative's house, but he was in close proximity of the marijuana, Your Honor.
Okay. And that's not why I wasn't satisfied, but I'm not satisfied because you said on the day in question, and the record has to reflect what day that was.
I believe it was August 3rd, 2022.
Is that the date? What's the date that you have, Ms. Ritter?
The date that I have, Judge, is July 22nd, 2022.
Mr. Casey, were you at the home on that date?
Yes. July.
Okay, that was a court date then.
Okay. Mhm. All right, are the people satisfied?
The people are now satisfied, Judge.
Okay, the court is satisfied. I will accept the guilty plea to the one count of, what is the actual count? Possession of, what is the actual count?
Possession
It's
of
regulation,
marijuana. Go ahead, I'm sorry.
it's regulation taxation of marijuana act, Your Honor.
Yeah, okay. Regulation tax. I see the RTMA, but what's that extra M for? All right. The court accepts the plea. I'm gonna set the matter for sentencing. As I indicated off the record, I am gonna request a pre-sentence investigation. The people have consented to HIDA, and I'm gonna do the pre-sentence investigation for two reasons. One, so that we can actually confirm, as we believe, that because it's a misdemeanor, that means he is eligible for the HIDA. So we'll confirm that. And then number two, because you've asked me also for this short probationary period, and I don't know what short is in your mind, but without a pre-sentence report, I won't even agree to a short. So let's do a pre-sentence investigation. They do ask for 4 weeks, so let's I can schedule it for, today is the 20th, but unfortunately I'll schedule it, because otherwise Mr. Flanagan, do I have sentencings on March 20th?
Yes, Your Honor, one.
But I should be in jury trial also. How many do I have that day?
24.
Oh, that's enough. I can't, with the jury trial, I can't put any more in. All right, and then I'm not available the next week. Let's go to, what about April 1st? Do I have any sentencings that day?
No.
Mr. Land, are you available April 1st?
That's a great day, Your Honor.
All right, let's schedule the sentencing for April 1st. Mr. Casey, you have a right to be sentenced in person, but you may consent to being sentenced on Zoom. Which do you prefer?
It doesn't matter.
But it's up to you. You have to tell me which one.
Zoom.
All right, then I'll schedule it at 9 o'clock on Zoom.
Okay.
All right, probation is gonna contact you, Mr. Casey, to do the pre-sentence investigation. They're gonna call you. If they can't reach you, they're gonna leave you a message and mail you a letter directing you to contact them. Please make sure that you do so that I can have a proper pre-sentence investigation. Mr. Land, please contact the clerk so that we can make sure that we have the proper phone number and address for Mr. Casey, okay?
Okay, thank you, Your Honor.
All right, Mr. Casey, it's almost, y'all kicked the can 10 months now. We're gonna settle it up soon, okay?
Thank you so much.
Thank you.
Y'all
All
stay
right.
safe, Your Honor, everybody. Take care.
All right,
Bye-bye.
I'll see you.
You too, bye-bye.
Hey.
All right, I guess I'm gonna go ahead and do Dawood.
Ready, Your Honor.
And then, Ms. Rahal, go ahead. I said Dawood, counsel, I'm sorry. Well, I did, it's your case, but I apologize.
I know what you meant, Your Honor. Don't worry.
All right. Ms. Rahal, raise your right hand and state your name for the court.
Good morning, Your Honor. Samara Rahal, interpreting Arabic for the court, state certified qualified.
Ms. Rahal, do you swear or affirm that you will translate from English into Arabic anything I say, counsel says, or the clerk says, and from Arabic into English anything Mr. Hermes says to the best of your ability?
I do.
Thank you. All right. This is case number 234539501. The people of the state of Michigan versus Bashar, middle name Fayyeq, and then last name Hermes.
ولاية ميشيغان مقابل بشار هرمز 2 3 4 5 8 9 5 0 1.
Defendant is charged with 1 count of gambling, disassociated person, and today is the date set for pretrial conference.
المتهم تهمينه انه عم يلعب قمار بمكان ممنوع يدخل عليه، واليوم تمهيد القضية.
Appearances, please.
Good morning, Your Honor. Alexandra Grimaldi requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Attorney General Monica Wilson. I'm so sorry. I am a 3L at Wayne State University in good standing.
أنا ألكسندرا عم بدرس الحقوق. سمحت لي مدعي العام من الولاية إنه أمارس القضية بحضورها. هي 3 سنة حقوق محامية عم بدرس. هي 3 سنة بالحقوق.
Permission granted.
وافقت.
Your
Counsel,
Honor, good morning. Attorney A.J. Down on behalf of Mr. Hermes.
your P-
سيد أمجد عم بيقول عن إنه هو داوود عم بيمثل سيد هرمز.
P67716, Your Honor.
أعطى رقم الدروس المحامي.
and Mr. Oh, I'm sorry.
All right, I was going to give up the number. Go ahead, Your Honor.
Okay, Mr. Hermes, state your name for the court.
سيد هرمز أعطينا اسمك.
Bashar Hermes.
All right, today is the date set for a pretrial conference. Mr. Daoud, how are we proceeding? Pause.
اليوم تمهيد قضية سيد هرمز. كيف رح نكمل؟
Your Honor, I've had an opportunity to speak with the Attorney General's office. The plea is charged pursuant to MCL 771.
L77. أنا حصل لي الفرصة أحكي مع مدعي العام حضرة القاضي، والاتفاقية حسب رقم القانون MC 1771 اعتراف.
Give me 1 second.
أعطيني ثانوي ثواني.
Okay. Mr. Hermes, do you want to accept the offer to plead guilty in exchange for a delayed sentence?
Yes.
سيد هرمز موافق تعترف إنه أنت مذنب لحتى يحكموا عليك مؤخر، يعني بينضف ملفك بعدين على القانون هيك؟
No.
موافق. Yes.
I am going to share my, well, no, I'm not going to share my screen because it's in English. Mr. Hermes, have you had an opportunity to review your constitutional rights with your lawyer?
سيد هرمز حصل لك الفرصة بالنسبة لحقوقك مع المحامي؟ فهموك حقوقك؟
نعم.
Yes.
And when you did that, did you understand your constitutional rights?
ولما حصلت هالشيء فهمت حقوقك أنت؟
نعم.
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial?
أنت فهمان إنه هيدا جنحة وحقك تكمل أنت بقضية، فهمان هيك؟
نعم.
Yes. Do you understand that if I accept this plea, you are giving up your right to a trial?
سيد انت فاهمين اذا انا وافقت بهالاعتراف هيدا عم تتنازل ترفع قضية، فاهمين هيك؟
نعم.
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea?
حدا هددك او وعدك باي شيء يعني خلال يعني بعد قبل ما نكون على القضية امامي، حدا وعدك او هددك لتوافق على؟
لا.
حدا هددك؟
لا. No.
No.
Are you currently on probation or parole?
انت على المراقبة حاليا او معفي من اي حبس؟
لا.
No.
No.
And do you understand, this was not on the advice of rights form, but do you understand that if I accept this voluntary plea from you today, and you are not a U.S. citizen, it may impact your immigration status?
انت فهمان اذا انا وافقت على جوابك اليوم او اعترافك اليوم بجوز تأثر على اقامتك؟
نعم.
Yes.
And with that understanding, do you still want to enter into this voluntary plea?
واختياريا بما انك انت فهمان هيك موافق انه تجاوب اليوم انه انت مذنب.
نعم.
Yes.
Raise your right hand for me, please.
ارفع ايدك اليمين.
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
بحلف بالله الشهادة رح تعطيها او رح تقولها رح يكون الحقيقة وبس الحقيقة.
نعم.
Yes.
Okay, who's going to question Mr. Hermes with respect to the factual basis?
I can, Your Honor.
المحامي رح يسألك بالسؤالات بالنسبة شو حصل هذا.
Okay, Mr. Daoud.
Mr. Hermes, were you on August 10th of 2023, were you in the city of Detroit, county of Wayne, state of Michigan?
سيد هرمس أنت كنت بمدينة ديترويت بشهر 8 يوم 10 2023 مقاطعة وين كاوني ولاية ميشيغان؟
نعم.
Yes.
And at that date and time, you did enter the Greektown Casino in the city of Detroit, is that correct?
وبهالتاريخ هيدا أنت دخلت على كازينو كريك تاون صح؟
نعم.
بمدينة ديترويت. Yes. True.
But at that time, you were in fact a disassociated person and not allowed to enter in that casino. Is that correct?
وبوقتها أنت كنت ممنوع تدخل على هذا المكان صح؟
نعم.
Yes.
And you agree that you entered that casino by trespassing because you had no right or legal authority or authority from anyone to enter that casino at that date and time. Is that correct?
وموافق أنت إنه أنت دخلت على المكان وعارف إنه ممنوع تدخل على هذا المكان، صح الكلام بمدينة ديترويت؟
نعم.
Yes.
Your Honor, I'm satisfied at this time.
أنا مقتنع إنه فهمان هو حضرة القاضي.
Are the people satisfied?
The people are satisfied, Your Honor. I apologize.
مقتنعين المدعي العام بالكلام.
The court is also satisfied, and I will accept a guilty plea to 1 count of gambling disassociated person.
وأنا كمان مقتنعة إنه رح أوافق إنه تهمة واحد إنه دخل على مكان بالأقمار وكان ممنوع يدخل عليه.
I'm sorry. Is there any objection to immediate sentencing?
حدا بيعارض إذا عليه حاليا؟ لا.
No objection.
ما عارض.
Is there anything on behalf of the people with respect to sentencing?
The people would leave this to your discretion, Your Honor.
في بتريد تقولوا لا نتركها عليك يا حضرة القاضي أنت.
Anything on behalf of the defense with respect to sentencing?
أي شيء من الدفاع بالنسبة للحكم؟
Yes, Your Honor, very briefly, Mr. Hermes is 44 years old. He is single.
حضرة القاضي سيد هرمس عمره 44 وأعزب.
He's working full-time, Your Honor. He has a good record.
وعنده ملف كتير منيح وبيشتغل وقت كامل.
Your Honor, he's not a violent person or a threat to the public. I would ask first to please grant him the 771 status.
حضرة القاضي مينو شخص عنيف ولا في تهديد للشعب. رح بطلب منك توافقي على الحكم قانون 771.
Your Honor, he has not attempted to enter into any casinos, and he will not do so in the future. He's done with that type of habit, if you will.
حضرة القاضي هو ما بقى يدخل على أي مكان قمار وخلص وانتهى من هالعوايد هول اللي بيتعود.
Lastly, Your Honor, I believe he's an excellent candidate for, if you're going to assess probation, I'd ask for non-reporting for short term. He would need some time to pay fines and costs, Your Honor.
أوكي. وأخيرا حضرة القاضي بطلب منك فترة المراقبة ما يحضر إذا بتوافي إنه ما يحضر على المحكمة.
Would your client like to make a statement on his own behalf?
اللي بيوكلك بيريد يتكلم أي شيء من ابن نفسه عنك أنت؟ No.
Having accepted the guilty plea, the court is going to impose the following sentence.
وافقت إنه اعترف إنه هو مذنب. رح أحكم بهذا الطريقة.
You shall not violate any criminal law of any governmental unit.
أنت ممنوع تعمل أي مخالفة مع أي جنحة مع الحكومة أو مكان.
You must not leave the state without consent of the court.
ممنوع تترك الولاية بدون موافقة المحكمة.
You must notify probation of any change of address, phone number, or employment status.
لازم تعلم إدارة المراقبة إذا غيرت نمرتك أو غيرت شغلك أو غيرت سكن المكان اللي ساكن فيه.
You must report to probation on a monthly basis.
لازم تحضر على إدارة المراقبة شهرية.
Court is going to impose a 8-month probationary period under the delayed sentence statute.
رح تنتشر فترة المراقبة والحكم مؤخر القانون اللي اتفقنا عليه يعني وقت اللي بينضف ملفك.
Final review date would be October 18th, 2024.
وآخر بتطلع على الملف بشهر 10 يوم 18/2024.
A midway review date is June the 20th, 2024 at 10 o'clock a.m.
شهر 6 يوم 2024. June the what, Your Honor, was that?
20th.
20 شهر بشهر 6 20 يوم. شهر 6 يوم 20 الساعة 10 الصبح رح أطلع على الملف.
If you have completed the terms and conditions of your probation by June the 20th, you are eligible for discharge.
إذا أنت كملت كل اللي بنطلب منك يعني الدفعات ما بعرف شو كمان شهر 6 يوم 20 أهلك إنه نلغي المراقبة بهالتاريخ.
You must pay the following fines, costs, and fees.
بدك تدفع الجزا والتكاليف.
$210 mandatory costs.
أول تكليفي إجباري $2010.
$100 fine.
جزا $100.
$80 supervision fees.
$80 علشان فترة المراقبة
total of $390.
بالكامل $390.
You shall not drive without a valid driver's license.
ممنوع تسوق إذا ما كان عندك رخصة شرعي.
You must attend Gamblers Anonymous at least twice a month.
بدك تروح مرتين على مكان وين في برنامج بيحكوا بالنسبة للأقمار.
You must attend Gamblers Counseling at least once a month.
مرة بالشهر مكان للأقمار المستشار مش مستشار.
There is a difference between Gamblers Anonymous and Gamblers Counseling.
في فرق ما بيقولوا له إنه الأقمار ممنوع ومستشار أقمار المستشار في فرق بين الاثنين.
And you must attend them both.
وبدك تروح على الاثنين.
Gamblers Anonymous twice a month. Gamblers Counseling once a month.
بالنسبة للأقمار مرة بالشهر للمستشار ولصف ممنوع الدخول على بالنسبة للأقمار. هيدا شيء تاني مرتين بدك تقعد عليها. هاي مجموعة.
The reason the probation is reporting because you must work through probation to get the referrals for both of those things.
السبب يلي قلت لك بدك تحضر على إدارة المراقبة لأنه هن هونيك هن بيدلوك أو وين لازم تروح والمكان هن بيساعدوك من هالناحية.
Mr. Flanagan, please make sure that the probation order reflects that the referral must come through probation.
عمل معروف عم تحكي للكاتب إنه تعلم إدارة المراقبة لازم الصف اللي طلبت منك عن طريق المراقبة هن بيدلوك وين لازم تروح وشو لازم وين تدفع والذي هو اللي بينطلب منك.
We're going to mail a copy of the court's order to your current address.
رح نبعث لك نسخة عن أمر المحكمة اليوم على عنوانك.
And probation is going to call you at your current phone number.
وإدارة المراقبة واحد رح يتصلوا فيك على رقم التليفون اللي عطيتنا إياه.
Mr. Daoud, please contact my courtroom and give us both of those things.
سيد داوود عمل معروف اتصل فينا وعطينا هالمعلومات الاثنين اللي قلت عنهم.
The courtroom phone number is 313-965-2295.
عم تعطي رقم إنه 313-965-2205 حتى تعطوهم المعلومات اللي طلبت منا.
Your Honor, if I may, I'm sorry.
No, go ahead.
I didn't know if you were done or not. I was just going to address the Gamblers Anonymous and the counseling with the language barrier. Would the court consider just the counseling one time a month until June, the review date?
بالنسبة للغة حضرة القاضي بس بدي أقول لك إنه بالنسبة للغة اللي ما عنده إياها فيك تعيفيه من المكان بيقولوا له مش المرتين بالشهر مش المكان اللي فيها مستشار مرة واحدة بالشهر.
Not unless probation tells me they can't find one for him to go to.
Okay.
إذا إدارة المراقبة قالوا لي إنه ما في مكان ليحضر عليها ويفهم ساعتها أنا بعفيه منها.
So that has to come from probation.
هيدا الجواب رح تجي من إدارة المراقبة.
Anything further?
في أي شيء تكملوا فيه؟
I guess I wanted to confirm that we didn't earlier, but Mr. Hermes, you are a U.S. citizen, is that correct?
سيد هرمس أنت عندك جنسية أمريكية صح؟ Yes.
And can he have time to pay fines and costs, Your Honor? Maybe a couple months?
فيكي تعطيه شهرين ليدفع تكاليف حق القاضي.
He has the duration of probation to pay.
عنده فترة المراقبة كلها ليدفعها.
That's all. Thanks, Your Honor.
شكرا.
All right, then we're all set. Everyone have a great day. Stay safe.
Thank
You
you.
too.
Thank you.
Your Honor.
All right.
Bye. Bye.
Mr. Brown, I wasn't all the way honest with you because I put that interpreter case in front of yours.
Thank you. It's fine.
All right. I think this is your client who left and came back. So let's see if the person on the iPhone can unmute and state your name.
Demetrius Green.
Yeah, this is your client who left and came back. Okay. Mr. Green, you can go ahead and start your video.
I'm trying. The host has asked you to start your video. Okay.
All right, this is case number 235966701. The people of the state of Michigan versus Demetrius Lamar Green. Defendant is charged with one count of attempt police officer assaulting, resisting, and obstructing. And today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And good morning, Your Honor. May it please the court. My name is Mark Brown. My P number is 39562. I appear on behalf of Mr. Demetrius Green. His attorney of record is Ben Gonick. Mr. Green, state your name for the record and let the judge know whether I have your permission to stand in for Mr. Gonick today.
Demetrius Lamar Green, and yes, you have my permission.
Thank you. Judge, Mr. Green and I have had an opportunity to review the pre-sentence investigation report.
You getting ahead of me, Mr. Brown, but go ahead.
I'm sorry. Okay.
No, go ahead. You're just so efficient. Go ahead.
I love you, Judge.
When you went over the pre-sentence report, you saw that Mr. Green didn't show up.
I certainly did.
Okay, that could be why you real proactive. But go ahead.
No, I try to be proactive
all the time. I know. I really enjoyed the way you practice, Mr. Brown. Go ahead.
So at any rate, right, Mr. Green, there were several back and forths with Mr. Green and the probation department. I don't think there's anything intentionally trying to avoid completing the report. I think there were some missteps. Mr. Green has advised me that he did reach out. And I know that the probation department did reach out to him. I think there's sufficient information upon which to base a decision as to the sanction in this case. Based upon the information that's presented in the report, he does have several pending matters in 36th District Court that are scheduled. He's trying to do something about them. He advised me that he is also attempting to work on his traffic matters in Hazel Park, Warren, and St. Clair Shores. He has a GED. He has one prior conviction, which is, I believe, let me see, I can't do my math here, 2006. That's like 18 years ago. I advised him he should probably look for go to Clean Slate, Operation Clean Slate, see if he can get that expunged. But no other involvement. He was working at Detroit Chassis.
Well, he might not be able to get it expunged because they had tried to, it was the Haida that was revoked. I guess he could because his probation closed. So yeah, okay.
I would hope he could. He was working at Detroit Chassis. He's been laid off. He's expecting to be called back. I don't think there's a specific date. But I would say, Mr. Green, I had an opportunity to interact with him before. He is a bright and intelligent young man. I think that he has made some errors in judgment. He wants to put those things behind him and go forward. So I'd ask the court to use its discretion to sentence him accordingly.
Ms. Ritter, any deletions, additions or deletions on the pre-sentence report from the people's perspective?
No, Your Honor, I don't see any on our end.
And would you like to address the court as to sentencing?
Judge, as far as sentencing, based off the information that the court does have from probation, There was a recommendation for an 18-month probation period. I'm asking the court to adopt that recommendation. There was a recommendation for 12 weeks of anger management classes. I'm actually going to ask the court, instead of the 12 weeks, to do at least 16 weeks of anger management in this case, Your Honor. Just according to the police description of the offense, it looks like there was a disturbance for a police run. The officers appeared at the store. They came into contact with Mr. Green. Mr. Green was a little, I guess, agitated, or he was a little angry and upset with the officer. So he did approach one officer and grab the officer by their duty belt and began to push that officer. Just based off that description of the offense, Judge, the people believe that there should be at least 16 weeks of anger management, and the 18-month probation recommendation is fine.
May I interject, Judge?
Well, you can, I
Respond.
believe you can respond, yes, because I believe she's done. Go ahead.
Okay, sorry. Good morning, Ms. Ritter. Judge, I had the opportunity to review the video in this case, and this is my word. I'm saying my word based on what I saw in the video. There were two people involved. Mr. Green, a long time ago, my father told me, mind your own business, and that's what somebody should have told Mr. Green, to mind his own business, because he's with his buddy and attempting with his buddy to get his buddy out of what his involvement. The buddy was talking, a long drawn out thing with the police, which I think escalated the matter. Mr. Green was not the instigator. I think he pulled away from a police officer, but the grabbing the belt and all that might have been the buddy. And I know it's written up in a synopsis form on this report, but I viewed the video. That's not what happened. And I'm not suggesting that, this is a trial, it should not be here. I'm suggesting that what his involvement was one of, what are you doing kind of thing. He resisted the police, indeed. I don't think there's any suggestion that he was a person who was assaulting, battering, opposing, other than pulling his arm away from the police officer. I don't think he needs 12 weeks or 16 weeks of anger management. I leave it in your discretion, but I just want to put that in there because I did look at the video, and it's not of the so he's the instigator or the person who's really involved in any active kind of resisting obstructing.
And would Mr. Green like to make a statement on his own behalf?
No.
All right. Mr. Green, when I read these type of reports, I just cringe and just, I mean, having lived through, at this point, I can't even, we lose count, which is unfortunate for us that we lose count, because, it always takes another tragedy for us to then call out somebody else's name. I sure would hate there to ever be a time, Mr. Green, where we're somewhere marching, protesting, going across Belle Isle Bridge, walking down to whatever, walking down Woodward saying, say his name, right? Say his name. I don't know a friend who could get me to, if my friends start arguing with the police, I'm just gonna walk away. I'm just gonna walk away from them and be like, she done for no reason. Cause why we gonna stand here and argue with the police?
I know.
The police asked you all to leave the store. I don't know what it was y'all wanted to get out that store that day, but it was just not important. That wasn't even no grocery store. Like, it wasn't even like, oh, I need grocery. It wasn't the pharmacy. Oh, I got to get my medicine. I got to get none of that. You out here fighting with the police to go back in the in the gas station? No, Mr. Green, your life is valuable, whether you want to believe it or not. And so I was disappointed reading your report on many levels. I was disappointed that your HIDA got revoked previously. I was disappointed that you didn't participate in the pre-sentence investigation. I was disappointed that another young African-American male is engaging in a level that could cost him his life. Those things disappoint me. And I don't like them. You seem to me to be a very intelligent young man. And you could be one of those individuals who you know, when you look at the resume, you get ready to throw the resume in the trash. And then somebody like Mr. Brown have to come and say, oh, you know what? I actually know him. And I know what his resume looked like, but I'm telling y'all, if y'all give him a chance, he gonna take this company next level. But it'll take somebody to speak up on your behalf if you keep on messing up your resume. I don't know you, Mr. Green. And so all I have to go by is what I read and what so you got to do better, because I mean, we haven't had any major like get on TV type of issues in Detroit, but you know, I wouldn't want your parents, your loved one, your friends, your family, your whoever to be out there say his name, Demetrius Green. You know, the only time we do that is the person dead, Mr. Green.
Yes, ma'am.
The person whose name we calling, they're dead. So whatever the police, sometimes the police be on some stuff, don't get me wrong. Oh, they be on some stuff sometimes. But then we have to look at the situation and say, you know what? I want us both to go home today. I want this officer who probably only getting paid, you know, way less than they can afford, or, you know, way less than they should. Some of that Super Bowl money should funnel back in. I'm not gonna get on that. I'm not gonna get on that to the police and stuff and the teachers. But you know, we want everybody to stay alive. I have friends that are on the police force. I have, you know, young people who, you know, want to argue with the police. So Mr. Brown, but I also believe in another chance, a second chance, a third chance, because if somebody didn't give me a chance and the people discount me, you know, I wouldn't be where I am. So I'm hopeful that, because also when I read the precinct's report, which again, I didn't have necessarily the benefit of your perspective, I said, oh, he's not a good candidate for probation. I was like, oh, he got outstanding warrants. He got his probation revoked. He's not a good candidate for probation. That's what I was thinking in my mind. So I was waiting to, you know, see what was going to happen today. And Mr. Brown did a great job standing in for Mr. Gonick, don't you think?
Yes, ma'am.
I think so. Because he convinced me. He did convince me. And so I did go ahead and staple a probation form to your PSI. Okay, so I am going to follow the recommendation of probation. I'm going to sentence you to an 18-month probationary period with a final review date of August 19, 2025. However, you are eligible for early discharge, Mr. Green, after only doing 9 months of that probation. So if you want to get discharged early, your 9-month review date, 1, 2, 3, 4, 6, 7, would be November. Oh, that's right around Thanksgiving. I'd be in a good mood. Mr. Green, if you catch me around Thanksgiving.
Yes, ma'am.
Oh my goodness, I'm gonna be in a good mood. That's the week before Thanksgiving. Oh, I'm gonna be just thinking about that food. I'm not gonna even tell you no lies. So I'm gonna set your 9-month review date for Thursday, November 21st, and that's the date that you will be eligible for early discharge. The terms of your probation are as follows. You shall not violate any criminal law of any governmental unit. You cannot leave the state of Michigan without consent of the court. You must make a truthful report to probation on a monthly basis and notify them immediately of any change of your address, phone number, or employment status. Sir, you will pay the following fines, costs, and fees. You're going to pay, Mr. Flanagan.
Yes, Your Honor.
Call Mr. Dupree back and tell him I'm ready for him.
Okay.
He was here, now he's gone. Okay, sir, you're going to pay $210 mandatory cost. You are going to pay a $350 fine, no restitution. Your oversight fees for 18 months is, I'm going to give you that amount, but know that, oops. So the total for 18 months is $630. But if you get discharged for example, at the halfway point, we will prorate that. So I'm going to tell you the amount that you have to pay in order to be discharged at 9 months. The court is going to impose a $50 pre-sentence investigation fee. And I am going to impose, let me see, oh, yeah. Okay, I'm going to add $30 urinalysis fees. And what I'm doing by that is you're going to have to submit to urinalysis for 3 months for me. 3. I held up 2 fingers. I meant 3. 3 months. And then if I'm satisfied with the results, if probation is satisfied, then you they can stop your testing. So I'm only going to do 3 months at $10 a test. So your total fines, costs, and fees are $1,270. In order to be discharged after 9 months, or at the 9 month point, I should say, at 9 months, then you have to have paid $955. So if you pay $955 at the 9 month mark, then if you're done with everything else, you can be discharged. Sir, you shall not use or possess any illegal substances. No marijuana without a valid medical marijuana card. No opiates without a valid prescription. Do not drive without a valid driver's license. I am going to order anger management, but I agree with you, Mr. Brown. I don't think I need to increase it. And in fact, I am going to decrease it. I'm going to order only, so I usually do 12. I'm going to order 8 weeks of anger management, eight sessions of anger management, but I'm also going to order the Choices program. And I think that might have been recommended. Yes. The Choices program through eBay, just an analysis, a reflection of the type of choices that we make. And Mr. Rice does a phenomenal job with that program. Sir, you have to pay all outstanding tickets you have with 36th District Court. According to this report, you have a balance of $748.80. You can either pay them in full, or it is sufficient for my purposes to discharge you from probation if you're on an approved payment plan through 36th District Court. So you can pay in full or get on that payment plan. You must clear up all outstanding warrants. And as a condition of this probation, you must keep your court date of April 9th before Judge Perkins. So you have several matters with Judge Perkins on April 9th. So you have to make that court date. Additionally, I want you to make a court date, if that's what you need to do, to clear up the warrants in 43rd, 37th, and 40th. The thing about it is, Mr. Green, you out there, and even though they're for traffic, some officers will arrest you on the traffic warrants, and some of them won't. So, you know, you just don't want to put yourself in that situation. Your license is currently suspended, and you probably can't get your license back without clearing up those warrants.
Yes.
And then let's see. There was a recommendation for 10 days of community service, and there was a recommendation for no alcohol, but of course, I'm not going to order no alcohol, and I'm going to hold the community service in abeyance. If you do everything you need to do, and I don't have any issues with you, then I won't order the community service. Okay.
Yes, ma'am.
All right. According to the report, you live on Bringard. Do you still live on Bringard?
Yes, ma'am.
All right, we're going to mail a copy of the court's order to that address. And then according to the report, your phone number ends in 5754. Is that still your phone number?
Yes, ma'am.
Then we're going to, probation will contact you at that phone number. Anything further?
No, ma'am.
Not from the people, Judge. Thank you.
Oh, Your Honor, thank you very much. It's always a pleasure to see you, Judge.
Always a pleasure, Mr. Brown. All right, then you both have a great day. Stay safe. Mr. Green, come on now. We don't want to be marching. I don't want to be marching to have to call out your name, okay?
And also, Mr. Green, like the pre-sentence report, when they call, you got to call back that day.
Okay.
In the next day, and you keep calling. Okay.
Okay.
And if you haven't
Thanks.
heard from them, Mr. Green, call the 36th District Court, call my courtroom. We'll get you in touch with who you need to get in touch with, okay?
Okay. Thank you, Judge.
All right, you're welcome. Have a great day. Stay safe.
Thank you very much,
Thank
Your Honor.
you.
Why they? Okay. All right, Miss Stevenson, I'm ready for you. I don't have any other. Mr. Flanagan, call Mr. Shark's office, please, and see if they can send somebody or give or communicate with the court like they're supposed to.
Okay.
All right. I'm ready on Jones.
Yes. Yes, Your Honor.
Judge, actually, Mr. Jones needs to return to breakout, please, Your Honor.
Okay, Mr. Jones, I'm gonna return you to breakout. And I'm gonna move you to number 3. All right. Then I'm ready on. You all just put something in the chat and I need to look at it because I only. All right, I'm ready on Thomas Cook.
And Judge, that's a co-defendant with Latrice Thomas Pearson, Mr. Dupree's client.
It's a good thing he just came in because I was ready. All right.
Good morning, Your Honor. I apologize. I was on the record in the courtroom.
No, that's okay, Mr. Dupree. I figured I got caught up with 2 things that were longer than I thought, so that's why I had him call you. Okay,
I know how that goes.
Yes. All right. I need Miss Thomas Pearson to get stationary. I'm not real sure what you're saying, but I need you to get stationary. All right. This is case number 23. Okay, I need Miss Thomas Pearson to stabilize her device. Okay, I'm ready for court, Miss Thomas Pearson, and I need you to be ready for court. I don't want to hear you. I want you to stabilize your device. I want you to be still, and I just want you to stabilize your device. Okay, this is case number 23447-6601. The people of the state of Michigan versus Onaya Thomas Cook. The defendant is charged with 2 counts of assault or assault and battery, and defendant 2, the people versus Latrice Kiwante Thomas. And it looks like she now is Thomas Pearson. Defendant is charged with 2 counts of assault or assault and battery, and today is the date set for final pretrial conference as to each defendant. Appearances, please.
For the record, John and Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Onaya Thomas Cook. Ms. Thomas Cook, ma'am, please unmute and say your full name.
Onaya Thomas Cook.
Good morning, Your Honor. May it please the court. Matthew Dupree, P80132, attorney for Ms. Thomas Pearson, who appears by Zoom. I don't know if the court wants her to unmute and state her name.
I do.
Ms. Thomas Pearson, you need to tap your device. You should see a microphone button in the bottom corner. You have to hit that. There you go.
Okay.
State your name.
Latrice Thomas Quantel Pearson.
Today is the date set for final pretrial conference. On behalf of Ms. Thomas Cook, how are we proceeding, Ms. Stevenson?
Thank you, Your Honor. Ms. Thomas Cook will continue her plea of not guilty and ask that this matter be set for jury trial, please, Your Honor.
And Mr. Dupree, on behalf of Ms. Thomas Pearson.
Judge, that is also her desire.
Court will continue not guilty pleas as to both defendant and set the matters for jury trial. And my next available jury trial date let me ask a question with respect to the complaining witnesses. When is the last time they appeared?
Judge, so I have in my notes that the complaining witnesses appeared on August 1st, 2023 at the pretrial conference.
All right, so okay, I'll leave the decision up to defense counsel. Mr. Dupree, my customary method at this time is that I place at least 4 cases on the docket for jury trial in the, of course, belief and understanding that some of those cases are going to settle out. I can place this case on a day where there's already some other jury trials, or if everyone is certain that this particular case is going to go to jury trial and you don't want to be bounced around, I can set you on a day where you would be the first in priority. Ms. Stevenson, do you have a preference?
I do not have a preference, Your Honor.
Mr. Dupree, do you have a preference?
Judge, I believe it would promote the judicial economy to set this against some other state cases. Why don't we do that?
Okay, so then in that case, the first available day where you are not the first in priority is, let's see. And I think I had been maxing out at 4.
I think the judges at Frank Murphy would scoff at only putting 4 jury trials. Sorry, Judge, I didn't mean to cut you off.
I mean, but you know what? Because I hate, and I know they have few, I don't, when I have to bounce somebody though, Mr. Dupree, it is a nightmare. Like,
I hear you.
Having to do that. But anyway, I'm maxing out at 4, which is why I'm now into September. So I could do September 4th or 9th.
Let me check those dates.
Or I could do, let me actually tell you, I could do, oh no, I can't do that day. I probably could actually do July 23rd.
I prefer September 9th.
Okay, and does that work for you, Mr. Dupree?
I was going to say, remarkably, Judge, I'm in a jury trial on July 23rd. So September the 9th sounds good to me.
All right, then I'm going to set this matter. And that's Thomas Cook. And Thomas Pearson. Okay, I'm going to set the matters for jury trial September 9th at 10:30. I will set a final pretrial conference. Does August the 9th work for final pretrial? Well, let me see. Hold on before I say that. I'm sorry. Hold on. No, not August 9th, because Mr. Dillard's case with is scheduled for the 13th. So does the 13th work for final pretrial conference?
Good for the defense, or well, this defense.
Fine with that, Your Honor. Ms. Thomas Cook is fine with that.
Okay, so then I'll set the final pretrial conference for August 13th at 9:10. And the complaining witnesses either should appear or I'm sorry, August. What date did I just tell you for the 13th? Okay. And that's at 9:10. The witnesses should appear, or the people should confirm that those witnesses are, one, still willing to prosecute, and two, are available for that jury trial date. Okay.
Understood, Judge.
All right. Anything further?
No, thank you, Your Honor.
Nothing on behalf of Ms. Thomas Cook. Thank you, Your Honor.
No, thank you, Your Honor.
All right, then, everyone, we're all set. Have a great day. Stay safe.
You too, Judge.
Thank you. All right, I'm ready on Turner. Who? Oh. Oh, Lord. Okay. And then Ms. Stevenson, I'm sorry, I skipped over Jones. Are you already on Jones? And who did you? Oh, that's who you sent me. That's who we sent back to the room.
Yes, and now Mr. Jones is ready, Your Honor.
Okay. Let me, you know what? I'm Mr. Shark. Okay. Let me bring in.
You know, Judge, he emailed me not too long ago, and I did indicate to him that the court did want him to call the courtroom. So I gave him the courtroom phone number.
He ain't gonna call. All right, well, we'll see if his client even connects. Okay, this is case number 164446801, the people versus Cheryl Turner. Defendant is charged with 1 count of child abuse, 4th degree. Today is the date set. Sir, remove your hat, please, for me. All right, Mr. Crumsey, I apologize to Ms. Turner because I was in mid-sentence. So give me 1 second, Ms. Turner. Mr. Crumsey, I got word that your lawyer is apparently in trial. And
yes, ma'am.
Okay, he's not able to appear today.
Yes, ma'am. He told me to stay in. That's why I'm still here. I apologize for interrupting you, but he told me to stay in,
Okay.
even though he is in trial.
That's what he told you.
Yes.
He knows me very well. So, Mr. Crumsey, though, I was trying to reach his office to get so I could schedule another date at the very least. But he was correct, and I'm glad that you did stay on. But I will adjourn the final pretrial conference, but I can't give you a date because I don't want to schedule it and then he's not available that day. So he will reach out to you,
yes,
and
ma'am.
we'll mail you a notice with the date, the new date on it. Okay.
Yes, ma'am.
Okay. Have a great day. Stay safe.
You as well.
Thank you.
All right.
All right, Ms. Turner, I'm sorry. This is case number 164446801. The people versus Cheryl Turner. Defendant is charged with child abuse, 4th degree. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Cheryl Turner. Ms. Turner, ma'am, please say your full name.
Cheryl Nicole Turner.
Today is the day set for final pretrial conference. How are we proceeding?
Your Honor, it was my understanding that the people were to determine whether or not they would be able to proceed with this matter, Your Honor, in that the case is from 2016, and at that time, the complaining witness was 17 years old. If the people have not been able to confirm their ability to proceed, we would move that this matter be dismissed.
Ms. Ritter.
Your Honor, so the court did set a final pretrial conference today and did want the people to confirm that the complaining witness was still available. Just to give give the court some additional insight, Ms. Stevenson is correct. At the time of the offense back in 2016, the complaining witness was about 17 years old. Now, Judge, the complaining witness is about 24 years old, and the people have been having trouble trying to locate the complaining witness. So at this time, Your Honor, the people cannot confirm the availability of Michelle Branham at this time, and we will not be able to proceed based off that information, Your Honor.
All right, today is the date set for final pretrial conference. The people have indicated that they have been unable to locate the now adult witness that was the subject of the charge back in 2016. And the court is therefore going to grant defense counsel's motion dismissing the matter without prejudice. And so Ms. Turner, of course, I'm sure your lawyer may have advised you that that means if the people were to locate the witness and the witness was willing to participate in the prosecution, then they could reissue the charges. You can have a seat on the front, not on the front row. You can have a seat in the courtroom, and we will get you a copy of the order of dismissal. Okay?
Okay, thank you.
You're welcome. All right, I'm ready on. Oh, I'll bring back Mr. Jones. Mr. Flanagan.
Yes, Your Honor.
Who is the Davis that's associated with Marcus Coleman? Marcus Coleman. Who is the attorney?
Maurice Davis.
Can you call Mr. Davis? He's usually here right on time.
Yes, ma'am.
All right. I'm ready on Jones. This is case number 234573401. The People versus Cleophas Jones. Defendant is charged with 1 count of stalking and 1 count of communication service illegal use. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. Cleophas Jones. Mr. Jones, sir, please say your full name.
Cleophas Jones.
Mr. Jones, today is the day set for a pretrial conference. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. It is my understanding, Mr. Jones, having had the benefit of counsel, having had the opportunity to review and advise the rights form, now wishes to avail himself of an offer from the people. He wishes to offer the court a plea of guilty to count 1 in exchange for a dismissal of count 2, Your Honor. And count 1 would be stopped.
Ms. Ritter, is that the people's offer?
That is correct, Judge. That's the people's offer at this time.
Mr. Jones, your lawyer has indicated that you want to accept the people's offer. Is that correct?
Yes.
Sir, I'm going to share my screen, and on the screen, you will see a constitutional rights form. My question to you, Mr. Jones, is have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, ma'am.
When you did that, did you understand your constitutional rights?
Yes, ma'am.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept the plea from you today, you are giving up your right to a trial. Do you understand? Whoops.
Yes, I do, Your Honor.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into this voluntary plea?
No, Your Honor.
Sir, drawing your attention to number 8, are you currently on probation or parole?
No, Your Honor.
Finally, sir, drawing your attention to number 11, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal, and if you were to change your mind about the plea, you would either have to request permission of the circuit court to appeal the conviction or request permission of this court to set aside the plea.
Yes, Your Honor.
With that understanding, do you still want to enter into this voluntary plea today?
Yes, Your Honor.
Sir, raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, sir, you may put your hand down, Ms. Stevenson.
Thank you, Your Honor. Mr. Jones, on December 16th of 2023, were you present in the area of 2280 South Edsel in the city of Detroit?
Yes.
While there, did you engage in a willful course of conduct involving repeated or continuing harassment of Lance Nicholas Wilson, the conduct being such that would cause a reasonable person to feel frightened and or harassed and or threatened, and such conduct did cause Lance Nicholas Wilson to feel frightened and or harassed and or threatened?
Yes.
Thank you. Your Honor, with that, defense is satisfied.
Are the people satisfied?
The people are satisfied, Judge.
The court is satisfied, and I will accept a guilty plea to one count of communication services illegal use. In exchange, pursuant to the offer from the people, the court will dismiss count one. Having accepted that plea, the court is going to set the matter for sentencing.
Judge, I think it's the other way.
Oh. Wait a minute. Oh, pled guilty to count one, I'm sorry. Stalking and dismissal, I'm sorry. All right, written it down wrong. The court is going to set the matter for sentencing, and I will set sentencing for Mr. Flanagan. Do I have any sentencings on April 3rd?
No, Your Honor.
Court is going to set sentencing for April 3rd. Mr. Jones, you have a right to be sentenced in person or on Zoom. Which do you prefer?
On Zoom.
Court is going to set sentencing for April 3rd at 9 a.m. on Zoom. Court is going to order a pre-sentence investigation and substance abuse evaluation. Probation is going to contact you by telephone. If they cannot reach you, sir, they are going to mail you a letter directing you to contact them, and they're going to leave you a message. Please make sure that you respond to their attempts to contact you so that I may have a proper pre-sentence investigation on the date of your sentencing. Anything further with respect to this matter?
Not from the people, Your Honor.
May we be heard as to bond, Your Honor?
You may, and so Mr. Jones's name sounds familiar to me. So does he have another case or something, or?
He does not, Your Honor. The reason it sounds familiar is because I have submitted quite a few motions to the court asking to modify the house arrest.
Oh, because of the this the one that was trying to shovel snow that day that it wasn't even but a little bit of sprinkle of snow outside.
So that is,
you don't have to answer, but
okay.
I will modify the house arrest.
Thank you so much, Your Honor.
Mm-hmm. Who is the subject of the stalking charge, Ms. Ritter?
The complainant witness is Mr. Lance Wilson.
Give me a little bit more information.
So if the court remembers, this is the bond, emergency bond hearing that the people filed for. Mr. Wilson is the husband of the former, I want to say, girlfriend of Mr. Jones.
Yeah, I remember. Okay, so I will remove the house arrest, but at this time, I'm not going to remove the tether. But I definitely remove the house arrest.
Thank you. Further, Your Honor, the court did restrict Mr. Jones' use of, telecommunication devices. So he's been.
It's lifted. It's lifted.
Thank you, Your Honor.
I haven't been advised of any violations, so don't violate. Don't mess it up now and violate.
Okay, no problem.
All right, so the house arrest is over. The restriction on communication services is lifted. He cannot have any contact with the complaining witness and the wife, girlfriend, whatever the status is, because I remember it was some looks and stuff the last time. So the two people, no contact. Okay.
Understood. Thank you, Your Honor.
All right.
Thank
So
you,
Mr. Jones, the order is going to go over to the tether unit right away, and then so they'll lift the house arrest. Oh, but okay, let me give a curfew. It's going to just be a 1 hour curfew. So like 11. No, because they're going to be mad at me if I do that. I'm just going to say no curfew because I just feel like they shouldn't be able to tell me to do that. Okay, we'll send it over and then you'll be all set, okay?
Thank you, Your Honor. I appreciate you. I really apologize for wasting this court's time today. I'm
No
so
problem.
sorry.
Oh no, Mr. Jones, that's what the citizens pay me to do. That's what the taxes are for. So we here, but.
I appreciate you, ma'am.
All right, you have a great day. Stay safe, and we're going to send over the order to the tether unit. So don't go outside just yet.
Okay. All right. Thank you.
Give us a minute. Okay.
All right. No problem.
All right. Okay.
Thank you, Your Honor.
You're welcome. Good morning, Mr. Teklinski. Good morning.
Good morning, Your Honor. Always a pleasure to appearing before you.
Thank you, Mr. Teklinski.
And I mean it too, Judge.
Thank you. I appreciate it. Your client isn't here. Is your client with you? There he is.
He's here with me, sitting to my right.
Okay. So give me 1 second. Good morning, Mr. Clayton.
Good morning, Judge.
You're standing in for Mr. Davis?
Yes, he's stuck in a hearing. He asked me to stand in for him.
Okay, I'm gonna take Mr. You know I never know how to pronounce your name.
Lugerai.
Thank you.
Yes.
I mean, okay. It's a lot of silent letters and a lot of letters that. Okay.
No apology, Judge. You did excellent.
Thank you. I'm gonna take Mr. Lugerai and then I'll be ready on Coleman and Mr. Lugerai. This is gonna be quick and easy. So this is case number 234471201, and it's the people versus Donnie Lugerai. Defendant is charged with gambling. Disassociated person. Today is the date set for a review. Counsel, your appearance, please.
Good morning, Your Honor. Mark Teklinski on behalf of Mr. Lugerai, who sits to my immediate right.
And your P number, counsel?
21319.
And Mr. Lugerai, state your name for the court.
Donnie Lugerai, Your Honor.
All right. Today is the date set for review, and I have a wonderful report that says Mr. Lugerai has done everything he was asked to do, and that he is ready to get off this probation. Is no need to extend it. Mr. Lugerai, are you ready to get off probation?
Yes, Your Honor.
Awesome. And I'm assuming this was it was a delayed sentence. So in addition to discharging you from probation, sir, I am also going to rescind your guilty plea and take this conviction off of your record and dismiss this case with prejudice. Okay.
Thank you, Your Honor.
You're welcome. So counsel, we will email you a copy of the court's order and you can get a copy to your client. Okay.
Thank you, Your Honor. I appreciate your kindness, Your Honor, and understanding, and I hope you have a good day.
Thank you, counsel. You as well.
Always a pleasure being before you, Judge.
Thank you, Your Honor.
Thank you, counsel. Counsel, you're gonna make my head get real big. They're gonna say, what happened? Why her head so big in the screen? It's a pleasure having you practice for me, counsel. Thank you.
It's a pleasure to appear before a smiling judge, too.
I'll try to keep smiling. Let's see if Mr. Coleman gonna keep me smiling.
Judge, that's what keeps you healthy, and me too.
Yes, Absolutely, absolutely.
Always
All
a
right.
pleasure, Judge. Thank you. God
Okay.
bless you.
You're
Bye.
welcome. Thank you.
Bye. Thank you, Mr. Galinsky.
All right. I'm ready on Mr. Coleman. Mr. Coleman, he's probably like, oh, I'm glad she's smiling too. Let's keep smiling.
Good morning.
Good morning. Mr. Coleman, thank you for your patience. Your lawyer had gotten stuck in another hearing. That's why it was taking me a minute, but he sent some backup, okay?
Okay.
All right, I'm ready on Coleman. This is case number 234469101. The People versus Marcus Lamar Coleman. Defendant is charged with assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
Good morning, Your Honor. Spencer Clayton appearing on behalf of Mr. Coleman, P number 77302. I am standing in for the attorney of record in this case, which is Mr. Maurice Davis. Mr. Coleman, can you state your name for the record?
Marcus Coleman.
Thank you. Ms. Ritter, you were slow on the unmute button.
I was. For the record, Your Honor, Christina Ritter on behalf of the people.
All right, today is the date set for a final pretrial conference. How are we proceeding?
Your Honor, I'm not sure if the court had made the requirement for the victim to appear today.
I don't know if I did either. Usually it would be at 9:06, but Ms. Ritter.
Your Honor, according to my notes, the complaining witness appeared at the pretrial conference on October 4th, 2023. The court did set this final pretrial conference today. I don't have notes requiring the complaining witness.
I wouldn't have required if they just appeared. So, counsel.
Understood. Your Honor, I haven't had the opportunity to speak with Mr. Coleman, but Mr. Davis's notes indicates that he would be entering a plea and seeking probation today.
Mr. Coleman, is that your understanding? Is there an offer from the people? What is he charged with? Oh,
It's
okay.
regular A and B.
Yeah. Mr. Coleman, is that what you want to do? Enter a plea today?
Yes, please.
Okay, Mr. Coleman, I'm going to share my screen, and when I do, on it, you will see a constitutional rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
When you did that, Mr. Coleman, did you understand your constitutional rights?
Yes.
Sir, do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept this plea from you today, drawing your attention to number 6, if I accept this plea, do you understand you'll be giving up your right to a trial?
Yes.
Sir, has anyone threatened you in any way or promised you anything to get you to give up your right to a trial and enter this plea today?
No.
Drawing your attention now to number 8, are you currently on probation or parole?
No.
All right. I need somebody to help me understand that. Okay. Finally, drawing your attention to number 11, do you understand that if I accept this voluntary plea from you today, you may be giving up your right to an automatic appeal to the circuit court? And if you were to change your mind about this plea, you would have to either request permission of this court to set aside the plea or request permission of the circuit court to appeal?
I understand. Yes.
Sir, with that understanding, do you still want to enter into this voluntary plea today?
Yes.
Raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Who's going to void dear Mr. Coleman with respect to the factual basis?
I can, Your Honor, if the
All right.
court would like.
Yes.
Mr. Coleman, I'm going to draw your attention back to April 21st of 2023. Were you in the city of Detroit?
Yes, I was.
And were you at Fort Street in the city of Detroit?
Yes, I was.
And did you come into contact with an individual named David Truster?
Yes.
And at that time, did you get in an altercation with him?
Yes, correct.
And did you strike him in the back of the head?
Correct.
And you didn't have any legal reason. He didn't give you permission to do that, correct?
Correct.
Okay, I believe that satisfies, Your Honor.
Are the people satisfied?
The people are satisfied, Judge.
The court is satisfied, and I will accept a guilty plea to 1 count of assault or assault and battery. Having accepted the guilty plea, the court is going to set the matter for sentencing, and I will set the matter for April 3rd or 4th. Are those good days, counsel?
Looking at my calendar, Judge, just a second. The 3rd is fine if that works for the court.
It does. Mr. Coleman, you have a right to be sentenced in person or on Zoom. Which do you want?
On Zoom, please, because I'll probably be at work.
Okay, then the court will set the matter for sentencing April the 3rd on Zoom at 9 o'clock. And prior to the sentencing, probation is going to contact you for a pre-sentence investigation. Unless, Ms. Ritter, are you requesting one?
You know what, Judge?
Because there's
No.
not an offer for, it's probably going to be the standard. Mr. Clayton, are you requesting a pre-sentence investigation?
No, Your Honor.
Then I won't order one, but I still have to schedule it in the future because the victim has a right to give a victim impact statement. I'm going to put it on the docket, Mr. Flanagan, for 8:59, please, so I know that I didn't order a pre-sentence investigation. So we're all set until April 3rd. Anything further?
No, thank you, Your Honor.
No, Your Honor. Thank you.
All right, then we're all set. Have a great day. Stay safe.
Thank you, you too.
Thank you. All right, I'm ready on oh, that's a review. Let me look at that. I'm ready on Foster and Murphy. I'm ready on everything, but let's see. That's Mr. Couch. Mr. Flanagan, can you send me, this is giving me barely any information. Can you bring me Mr. Couch's file or send me his probation order or something? This is giving me no information.
Yes, Your Honor.
Thank you. All right, so then I'm ready on Foster. And well, did you all speak to Smith?
Not yet, Your Honor.
What about Howard?
No. And Ms. Smith, if she's okay, she can skip the breakout room, but not talk to her in breakout today.
You said if Miss Smith is okay with me, okay. Ms. Foster, please accept to join the breakout room and wait for the lawyers to come in to speak with you.
I think Ms. Foster may have left and come back.
Oh, okay. I didn't have Foster highlighted, so I didn't know. Oh, yes, I did. Foster. Oh, yes, I did. Ms. Howard, please accept to join the breakout room and wait for the lawyers to come in to speak with you. So I think you're ready on Foster and Murphy.
Yes, Your Honor.
Okay. Do you want me to take them in any particular order?
However they appear in the document.
All right. Then I'm ready on Foster, and then I guess Ms. Smith is appropriate for court. So you're ready on her?
Yes, Your Honor.
All right. So I'm gonna take Foster, Murphy, and then Smith. This is case number 184510801, the People versus Shaquan Foster. Defendant is charged with assault or assault and battery. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Shaquan Foster. Ms. Foster, ma'am, please unmute and say your full name.
Shaquan Foster.
Today is the date set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Foster continues her plea of not guilty, asks that this matter be set for jury trial.
When is the last time the complaining witness appeared?
Judge, so interestingly enough, I don't have any notes about the complaining witness appearing.
Ever?
No.
All right, the court is going to set the matter for jury trial.
Your Honor, if the complainant has never appeared, I move for dismissal for the complainant's failure to appear.
The motion is denied. I'm going to set the matter for jury trial. One where it wasn't. This is February, right? Okay, I'm going to set the matter for jury trial, April the 22nd. I'm going to set a final pretrial conference for Mr. Flanagan. How many do I have on March 15th?
$25.
I'm going to set a final pretrial conference March 15th at 9:06. Well, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. The bond will continue. So, Ms. Foster, I don't know how we've gotten this far without the complainant ever being required to appear, but I'm setting your matter for final pretrial conference on March 15th, and if the complainant does not come on that day, then the April jury trial won't go. I'm kind of putting a placeholder in there, okay? Anything further with respect to Ms. Foster?
No, thank you, Your Honor.
Nothing on behalf of Ms. Foster. Thank you, Your Honor.
All right, you're welcome. Thank you, Ms. Foster. Have a great day. Stay safe.
You too.
Thank you. I'm ready on Murphy. This is case number 2244-49801. The people of the state of Michigan versus Larry Murphy. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Larry Murphy. Mr. Murphy, sir, please unmute and say your full name.
Larry Murphy.
Today is the date set for final pretrial conference. Ms. Stevenson, how are we proceeding?
On behalf of Mr. Murphy, Your Honor, if the complainant's presence was required and the complainant is not present, we move that the matter be dismissed, and the alternate, we ask that this matter be set for jury trial.
Ms. Ritter.
Now, I do have notes on this case, Judge, that the complaining witness appeared on April 18th of 2023, and the court set the pretrial for today, and I don't have notes that the court required the complaining witness's presence.
All right, and I probably did not, but I am gonna set a final pretrial conference where the people must confirm that the complaining witness is still interested in prosecuting the matter. So let's go with a final pretrial a jury trial of what happened to that jury trial? Hold on, let me look in my other book. Mr. Flanagan,
Yes, Your Honor.
can you go to June 17th and tell me if I was I was trying to hold out because Mr. Crowley is representing himself. Don't worry about that. I'm gonna set this jury trial for July 23rd. Can you tell me when the final pretrial conference is for Hampton that's on that day?
Yes, Your Honor. February 26th.
Oh yeah, that's coming up. And I don't know if they're gonna go to trial. All right, I'm gonna set this final pretrial conference for Mr. Murphy for April let's see. April the 29th. The complaining witness should either appear or the people must confirm that the complaining witness is available for jury trial and willing to prosecute the case. Anything further?
So Judge, that's the jury trial set for April 29th?
That's not what I said. I said the jury trial is scheduled for, that's a final pretrial. The jury trial is scheduled for July something.
Okay.
What day, what did I say? July what?
23rd.
Okay, got it, Judge. Nothing further from the people.
All right. Then we're all set, Mr. Murphy, until April 29th, sir, at 9:10.
9:10.
Oh, no, I should set that at 9:16. Put that at 9:16. That was my new date time for the witnesses needing to appear. All right. All right, sir. Have a great day. Stay safe.
Okay, thank you, Your Honor.
You're welcome. I'm ready on Smith. This is case number 214547001. The people of the state of Michigan versus Laquana Smith. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, appearing on behalf of Ms. LaQuanta Smith. Ms. Smith, may I please say your full name?
My name is LaQuanta Lachey Smith.
Today is the date set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Smith continues her plea of not guilty and asks that this matter be set for jury trial.
The court continues a not guilty plea on behalf of Ms. Smith. And sets the matter for jury trial. When is the last time the complaining witness appeared?
So, Judge, I have that the complaining witness appeared at the final pretrial conference back in September of 2023. And I believe that's when Ms. Smith failed to appear and that was a capias issued. So when the court arraigned the bench warrant, the court didn't require the complaining witnesses to appear on either September 20th or November 15th.
I'm gonna set the matter for jury trial May 20th. Mr. Flanagan. Do I have Jackson and New?
Yes, Your Honor.
That's it, right?
Yes.
Court is gonna set this matter for May 20th with the final pretrial conference of April 19th.
Yes, ma'am.
People should confirm their witness. Anything further?
No, thank
Yes,
you, Your Honor.
Yes, ma'am.
I wanted to get the times, the time. I got the dates, but I didn't get a time.
Jury trial is at 10:30. Final pretrial conference is at 9:16.
Thank you.
You're welcome. Anything further?
Nothing on behalf. Thank you, Your Honor.
All right, we're all set. Have a great day. Stay safe.
Yes, ma'am. You as well.
Thanks, bro. All right. I'm ready on couch.
Your Honor.
Well, I'm not ready on couch. I didn't mean that. Yes.
Could we do Howard or Mr. Byrd?
Mr. Byrd not even in the courtroom.
Morning, Your Honor.
Good morning. Okay, something, my computer acting funny. All right. I'm going to print Mr. Couch's order so I can see it. And actually, Mr. Byrd, give me one moment. I'll be right back.
No problem.
Your Honor, is it okay if I just step away while you do the reviews?
Yes.
Thank you.
planning.
Judge, oh, you're muted.
Yes.
The court reporter just stepped out to the restroom. Yes.
All right, I'm ready. This is case number 126286901, the People versus Angel Marie Howard. The defendant is charged with 1 count of embezzlement. Today's the date set for review. Appearances, please.
Yes, Your Honor. Brandon Bird on behalf of Angel Howard. Ms. Howard, please state your full name for the record. Unmute yourself and state your full name for the record, please.
Angel Marie Howard.
Today is the day set for review. According to probation, Ms. Howard was, what happened? Oh, here we go. According to probation, Ms. Howard was placed on a 12-month probationary period in January 2013. She is making payments towards her restitution. Her current balance is $4,275. She attended the economic awareness program and completed 4 hours of community service. I know I didn't order anybody to bring a letter in from the landlord. I know I didn't. Mr. Bird.
Your Honor.
And I don't even have a letter from the landlord attached. So that's interesting, but let me pull it back up. Okay, Mr. Bird.
Respectfully, Your Honor, my client brought that letter in because she was showing why she wasn't able to make payments. I spoke with my client, and she was telling me after the last hearing, you had asked her to explain why she wasn't making payments. And that was one of the reasons why she wasn't making payments, because she wasn't caught up on her rent. Her lights got cut off a couple times during that period. Her husband wasn't able to work, had 2 hernias. He's back at work now, Your Honor. She had temporary guardianship over her grandchild. So it was a lot of things going on, and she wanted to bring some sort of proof to you today that that was one of the things that was going on, is that she wasn't able to pay her rent. But she wanted to show you that she's caught up on her rent now. Things are looking better for her. Things are looking better for her due to the fact that her husband is working again, and she could pay about 150 to 100 a month. They both are employed. One of them worked for a grocery store. She's a manager to a fast food restaurant, but I mean 50 to 100 a week. Sorry, I said a month, but she said she could pay 50 to 100 a week, Your Honor. So respectfully, we're just asking to give her some time to pay for it. I know that would almost be like a 4-year period, but my client is trying her best without having to without having to put herself on the street, you know. And if she is on the street, then she's not going to be able to pay restitution. If she loses her job, loses her home, she really won't be able to pay restitution. So we're just asking to give her opportunity to keep on working towards that restitution.
Yeah. So, okay. I don't know if she. So the letter, the letter means nothing to me. I'm gonna just let you, for real. The letter means nothing to me. It could have been created by anybody, right? It means nothing to me completely. It's on a plain piece of white paper. It doesn't even have a real signature. So I could care less about that letter. It adds nothing to me. Number two, I'm certain I said that she had to provide proof of her income, not that she behind on her rent, because she's made no good faith efforts to pay this restitution. And the thing about that is you have to make a good faith effort to pay. You have to make a good faith effort to pay. So I'm going to extend the probation for sure. I'm going to extend her probation for 12 months. And she needs to make a good faith effort to pay the restitution in that 12 months, or there's going to be some other consequence. Mr. Flanagan, what was her original amount? Because this didn't say she paid anything still on this review. They don't say anything about her making any payments. It just said a letter from her landlord that's typed up, that could have been typed by anybody in the world, was attached. How much was her original balance?
Oh, I'm sorry, Your Honor, I was muted. $4,450.
So she's made a small payment. And so now from, yes, we were here like on January 18th. And yeah, okay. So the letter is of zero consequence or in assistance. I'm going to extend the probation until January 2025. And I'm going to give some review dates. And in those review dates, every time we come here, it's going to be an ability to pay hearing. If Ms. Howard has not paid anything, there's going to be a consequence. You can't be on probation for a year and then you've paid almost nothing. And so even if she was 4 months behind in her rent, that didn't say anything about the first part of her probation. She paid nothing during the first part of the probation. Court extends the probation to January 16th of 2025. The next review date is May 2nd. And she must have made some payments. $10 a.m. Or present documentation other than a unsigned typed up letter from a landlord about her financial status. But when we do talking about abilities to pay, we're talking about bank statements. We're talking about tax returns. We're talking about other stuff, not a letter from some person we're talking about official documents. Anything further?
Nothing further, Your Honor. Thank you.
All right, we're all set. Have a great day. Stay safe.
Thank you, Your Honor.
You're
You have
welcome.
a great day as well, Your Honor.
All right, you as well, Mr. Bird.
Thank you.
All right, I think I'm ready on couch. I'm ready on couch. No, Mr. Flanagan, you sent me, this isn't his probation order. I need the original order. Do you have the original probation order?
No, Your Honor.
Okay. This is case number 05139111, the People versus Carlton Leslie Couch. Defendant is charged with operating while visibly impaired, and today is the date set for review. And this is, okay, appearances, please.
Janice Stevenson appearing on behalf of Mr. Carlton Couch. Mr. Couch, please tell the judge your full name.
Carlton Couch.
This is just not, okay. So, Mr. Flanagan.
Yes, Your Honor.
Okay. Can you bring me his file, please? I need to see the file.
Yes, Your Honor.
Mr. Flanagan.
Yes.
Is it a real file or is it some created thing?
Yeah, it's not the real file. It's just a sleeve with a bunch of ROAs.
Okay.
Can we still bring it up?
No. Can you call probation and see if they have the original order?
Yes.
Because this is useless. All right, Ms. Stevenson.
Thank you, Your Honor. So the remaining condition is, I believe, payment of the balance of costs and fines. Mr. Couch was able to make a $100 payment, I believe, this past Friday. Mr. Couch works 7 days a week, Your Honor, and showed me his direct deposit or his bank statement, Your Honor, indicating that after child support is taken out, Your Honor, he actually has almost a negative balance in his account. So Mr. Couch does wish to be able to continue to make payments toward these costs and fines. He says he can continue to pay $100 on his payday every other week.
That's not going to make it. That's not going to make it. First of all, it's an old case. Second of all, nobody is, you're saying his only remaining condition is some money paying, but I need to know what the conditions were. Judge Baltimore signed an order reinstating a probation with no conditions. on here, and this is a drunk driving case. So if we're reinstating probation, what are we reinstating exactly?
So I do see from the report that I have from Ms. Tucker that, the remaining conditions show that he's to be fingerprinted and paid, and he has been fingerprinted, Your Honor. I'm not sure what other conditions remain outstanding.
I don't see anything that talks about fingerprinting. Where do you see that at? Furthermore, Miss Tucker is only apparently going by this new order that Judge Baltimore signed. You all cannot, okay, this is a drunk driving case. So at the very least, the report should say he completed victims impact panel. He completed alcohol highway safety. He completed this, and the third. I need to know that he completed these other things that I don't see anywhere. So maybe Miss Tucker needs to come on Zoom, because I don't understand how I don't understand what judge, I don't understand. I see it was ordered back a long time ago in 2004, 20 years ago, some urinalysis. And then he was scheduled for show cause by Judge Farmer in 2005. So when did he do these other things? He was scheduled for show cause June 23rd, 2005. I'm sorry. He was supposed to come for show cause July 15th, 2005. And then the next things that is on here are some things. And then in 2021, he filed bankruptcy. And in 2022, here we are for an arraignment on the bench warrant. When did he do the things? Between the show cause and today.
Actually, I'm not certain as to what the things are that he was to have done. I do see from, again, the report that was provided to me that the remaining conditions are to be fingerprinted and to pay the balance of costs and fines. I don't know what the initial conditions of probation were. And I guess I would argue that if there is no order available to the court, not in a position to know what it is he's charged with having violated. So I would again just ask the court to give Mr. Couch the opportunity to satisfy the balance of costs and fines.
Mr. Flanagan, what did probation say?
Your Honor, they don't have the probation order, and they said the file was destroyed.
So then what is this $520 court fees that's court cost that's on this order? And a $180 fine. Where did we get that from? And then on here it say, on page 2, it says $360 in supervision fees. And on page 1, no, and then it has $520 fines, $200 for some other, $180 fine. Like, this is not, what is, okay. All right. Yeah, I'm gonna close the case out without improvement. I can't do this. So,
Thank you.
we're all set.
Thank you, Your Honor.
You're welcome. I'm ready on Jemerson. Case number 224500301, the people versus Anastasia Jemerson. Defendant is charged with assault or assault and battery. Today is the day set for trial. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Anastasia Jemerson. Ms. Jemerson, may I please tell the judge your full name?
Anastasia Jemerson.
Are the people ready to proceed?
Your Honor, the people are not ready to proceed, but if the court allows, I would like to make a record.
You may.
Thank you, Your Honor. So, Your Honor, in preparation of today's trial date, and I'm sorry, Judge, I believe that's Officer Walsh, one of the assistant officers present in the courtroom. May he put his appearance on the record?
Yes.
Officer Walsh, badge number 4984.
What's your first name, officer?
Jacob.
Thank you so much.
Thank you, Your Honor. So in preparation for today's trial, Your Honor, I did get in contact with my officer in charge, Officer Ryan Paul. He did attempt to make contact with the complainant witness, Mr. Jerry O'Neill. He made several attempts to call the numbers that he had on file for Mr. O'Neill. They were unsuccessful. He ended up going out to the last known address of the complainant witness and left a subpoena on his door. Earlier this morning, Your Honor, during court, I did receive a voicemail from a Mr. Jerry O'Neill indicating that he did receive the subpoena. However, he was not interested in further pursuing this case. So at this time, Your Honor, the people will not be able to proceed to trial due to the complainant witness's refusal to prosecute the case.
Ms. Ritter. Ms. Stevenson.
Okay, sorry, Judge. On behalf of Ms. Jemerson, we move for dismissal.
Well, there's a not unidentified device that I'm trying to let in, but it won't join. I don't know. Let's just confirm. Okay, well, it's not, I don't know what, it might be stuck. Today is a day set for trial. The people have indicated that their witness does not wish to pursue the prosecution of this matter. Court is going to grant defense counsel's motion and dismiss the matter without prejudice. Ma'am, please have a seat on the in the courtroom, and I will get you a copy of the order of dismissal for your records. Anything further?
No, thank you, Your Honor. Thank you.
Nothing on behalf of Ms. Jemerson. Thank you, Your Honor.
Thank you, Your Honor.
All right, then we're all set.